Hello, and thank you for joining me. I'm so glad that you took this time out of your day to be here with me and get a little education on the importance of estate planning. I'm calling this Estate Planning 101 because my goal is to help you understand by the time we get to the end all the basics. What's a will? What's a trust? Those are the typical documents. But even more so, why is estate planning important? And why is estate planning important not for the rich, not just for the wealthy? But really, why is estate planning important for you, for everyone, for all families? And that's really what I'm hoping that this big takeaway, or what I'm hoping will be your biggest takeaway by the time we get to the end of this presentation today. I'm also hoping that we're going to have some time here at the end for questions. So please use the chat box and put your questions in there as they come up. And I will definitely be reviewing that at the end. As well as we go through this program, I'm also going to be asking you some questions. So please use that chat box to let me know how you're doing and how what I'm saying is landing with you. If you have questions or want to share a story or even just give me an emoji, any interaction is great. I welcome and value it all. So without any further ado, I suppose let's just jump right into it. I want to say that as I talk about these things today, it is likely to cause you some concern, raise some questions that maybe you haven't thought of before, and that's perfectly normal. And I want you to know that although clearly I can't give you personalized advice right now in this session, if you wait until the end, I will make you an offer to meet with me one-on-one so that we can take some time to go through what your specific goals are, what your objectives are, what's important to you and your family, and what you need to do in order to protect them and secure your future. So just hold on, stick with me, and I'll even offer you a savings on planning. So one thing I'd like to start off with saying is that a lot of people believe that if they think about estate planning or start to do estate planning, that one, they might jinx themselves. And that's never happened, at least not in my experience. Another thing that a lot of people think about, and this is a big myth, and I sort of alluded to it already, but it's this idea that you don't really need to plan unless you've got a certain level of income or a certain level of wealth. And that's this idea that it's only necessary if you have stuff or based on how much you have. And kind of what goes along with that too is this idea that you don't really need to plan or think about it when you're young and healthy. A lot of people think, oh, yeah, I'm young and healthy. I don't need to think about it. I'm not, or I don't have enough money. So they think it's something that's really for the wealthy or for the elderly. And I'm here to tell you that that's just not true. Those are big myths, and it's not reality. And you are definitely in the right place here if you have someone, anyone that you want to protect. And if you have something, anything that you want to protect. So it doesn't matter how many people or how large of an estate you have. It's important to plan, and especially if you've got children, because it's very important that you consider who's going to raise them. And that's the whole idea of guardianship. And we're going to talk about that today as well. So the reality is that estate planning, yeah, it's for you because we're talking about you and your family and your assets, but even more so, it's about your family because it's your family that's going to have to deal with it. It's the people that you leave behind that are either going to have a real simple path, and it's going to be easy for them to understand what your wishes were and how you wanted your assets distributed and how you wanted your children cared for, or it's going to be confusing and it's going to lead to conflict because it's not going to be clear. So really, estate planning is about you taking the time now while you can, while you're alive, to put your desires and your objectives into place, pen to paper, so that the people that you love the most and the people that you leave behind have the easiest, most simplest time possible so that they can stay out of court and so that they can stay out of conflict. Before I get into the details of wills and trusts and all of that kind of legal jargon type of stuff, I did want to take a couple minutes to tell you a little bit about myself. That's me there. My name is Gina DePrima. I'm an attorney, and I've been practicing law with my own firm, DePrima Law, for about 20 years now. I became an attorney with the desire of really making a positive difference for family and keeping them out of court and keeping them out of conflict. Because you see, I learned at a very young age how destructive the court system is for families. My parents went through the worst divorce, we call it like War of the Roses kind of thing, if you can imagine. I had to testify in open court against them. So I saw at a really young age, as a teenager, that the court system is exactly what it sounds like. It's one side versus another side, meaning it's an adversarial process, a he versus she, if you will. And it's not designed for a meeting ground. It's not designed to promote peace or amicable resolutions. It's designed for one side against the other. So it was a real motivating desire for me to try to help families solve their problems without having to deal with that. So I did that through the process of mediation and through litigation. Even though I was in court representing families, I was always trying to help my clients see the forest through the trees, move them through the process in the most amicable way possible, in the way that really respected their children and their family and the family unit as a whole. And I continue that to this day, and I carry that forward under this umbrella of estate planning services, because I've realized in my 20 years of practicing and in litigating how often it is that families end up in court or in conflict when a loved one dies or when a loved one becomes incapacitated. In fact, the numbers are staggering, and it's higher than the number of people ending up there because of a divorce situation or a family court custody situation. So I changed my focus around the time of COVID to really expand and offer services to families in the event of their death or incapacity, so that I could help them get ahead of a crisis and keep their family safe and at peace, instead of just jumping in the middle of a crisis. And you can see here, excuse me, on my screen, these are some pictures that I'm sharing with you with my family, because again, I know and understand that what you're doing here today, why you're here, it's important for you, yes, but it's really mostly important for the people you leave behind. And that's my dad, my stepmom, my beautiful wonder twins here, my brothers, my pets. And I want to know that if something happens to me, that they're going to be cared for, that they're going to know exactly where my stuff is, my stuff meaning my assets, they're going to know exactly how to access it, and they're going to know exactly what to do with it, and that it's going to be easy and seamless. And I most certainly don't want them going to court. My why came to be, again, around the time of COVID, when I was appointed, unfortunately, to represent a young 12-year-old boy who lost his mother unexpectedly, and then had to come and talk to me, a lawyer, about who he'd want to live with, his biological dad that was fighting for custody of him, or the person that he identified with, that he lived with for 12 years of his life, who really had no legal authority over him, but it was who he perceived to be his dad or his grandma. And it's heartbreaking. And when I tell you that this wasn't the first child that I had represented in my 20 years in this circumstance, and it's just heartbreaking to see. And I will tell you that's just one way that families end up in court and in conflict after someone dies. It's because parents have not put in place any legal documents to set out who's going to care for their children and how they want their children cared for. The second thing that happened was that I had referred my dad to the best estate planning attorney in the area. And the reason being is because although I did some estate planning, I did it on a scale that, I never held myself out as an estate planning attorney. I thought, well, sure, I can help you. I can give you a basic will. I can give you a basic power of attorney, and I'd give you your documents and you'd be on your way. But that never sat right in my gut. I didn't like it. Because in my gut, I felt like, how do my clients really know what they're doing here? How do I know or have any assurance that their family is going to understand this plan when they need to understand the plan? So I referred my dad to somebody else, and I referred him to somebody else because I was expecting something very different than that. I referred him to the best estate planning attorney in the area. And unfortunately, his experience wasn't too far off from what it would have been had he been a stranger at that time planning with me. And what that looked like was this. He went in, he signed a retainer agreement, he was billed hourly, he ended up paying several thousands of dollars, walked out with his documents after only meeting with the attorney for a very short period of time, walked out with a will, a couple of trusts, and that was it. Now he was excited, he was happy, he, checked the box, Gina, I did it, I'm all set. Right. But the problem is he had me look at these documents And I can guarantee you that our family would have 100% ended up in court, and we would have 100% ended up in conflict because there were major, major flaws. One, me being not only an attorney, I should understand this stuff and be able to read it, which I could, and it wasn't drafted correctly. Two, being the named executor, you would think that I would know where his assets are, how he would want them distributed, how he would want everything handled, that there'd be a roadmap for me. There wasn't. There was nothing. In fact, if he would have passed away, I would have had zero idea. And that's why I say for sure we would have ended up in court. We would have ended up in conflict. There's no question in my mind, because there was no effort put into summarizing what his assets were, giving me, the named executor, any direction of what to do. He was basically just charged every 6 minutes at some ridiculous, hourly rate for a set of fancy documents that allowed him to feel good about himself, but in reality did very little in terms of creating real peace of mind. I like to think of it as this false sense of security. And unfortunately, that experience is not unusual. And if you go and you talk with other estate planning attorneys, or you talk to friends or family members that may have already done this, I encourage you to ask them what the process was like. I encourage you to ask them if they paid hourly, and if anything was put in place to keep their plan updated over time. If anything was put in place to document what their assets were or where their assets are, so their family would understand that. Because my guess is, and I'm not a gambling type of person, but I'd put money on this, that they weren't, because that is the traditional way of estate planning. It's very much document driven and transactionally based. And that is not the way I do it. And so this brings me to my why. After having represented this young man and knowing that this kind of thing goes on in the background, right, with when parents don't name guardians for their children, and after having sent my dad out and seeing what his experience was with the best estate planning attorney in the area, and knowing how it was really the same that I would have offered with zero, or I wouldn't say with zero training or experience. Of course, there was some, but it was the way that I was trained 20 years ago, right? But it was the thing that I would have offered, not even being an attorney, really practicing in this area, that those events were real eye openers for me. Okay. And so that's my why. I do this now because I don't want to see any other children or any other families have to go through what this little boy had to go through. I don't want to see anybody have to go through what my dad went through. And quite frankly, what we are still to this day trying to fix. And because it's all me, it's part of me, it's who I am. I'm a peace warrior at heart. I always have been. Like I said, that's why I became a lawyer, and practicing estate planning now in this new way that I do it. I went out and I got certified to become a personal family lawyer. So now I'm not this document-driven transactional estate planning type of an attorney that you would find if you were just kind of Google searching, most likely, or going to anybody else in the area, because I don't know of any other personal family lawyers in the area. But what that means is that I now am able to serve my clients in the role of a personal advisor, where I'm in a position to offer them this lifetime relationship. And that's so important to me because it's necessary. It's necessary, especially if you want to have a plan that's going to actually work in the end. And that's my son. And he's here on my mission slide so that I can show you that this is all part of my mission. It's my family helping you and your family, because again, I don't see myself as just drafting documents. I see myself as becoming your partner, your family's partner, and your family's personal advisor for life. Here now to help you put in place a plan, here later to answer questions for you, make changes as you need, give you other assistance as you need, and later when your family really needs somebody the most. So that's the last thing that they got to think about. Who am I going to talk to? How am I going to work this out? So that's all part of it, is standing in partnership with you and inviting you, when you work with us as a client, inviting you to become part of my family as well. So if you have someone that's coming to mind, your family members who you're looking to protect, I'd love for you to just put that in the chat, make a note of it, because I want you to keep that in the forefront of your mind as we go through these things today, because really that's what we're talking about. And that's who this is for. What are you going to learn today? Well, we're going to talk about all the basics, like I said, all the basics of wills and trusts and why it's important, and guardianship, and what estate planning is. But more importantly, hopefully, why it's important. And we're going to do that by looking at life through the lens of a made-up family called the Smith family. They are an average family. I'm going to introduce you to them soon on the next slide. And we're going to put them through a couple of tragic events just to see how life would unfold for them, so that you can maybe draw some parallels and learn from what they would go through to what it might look like in your family. So here we go. Let's meet the Smiths. Oops. Give me a second. Why isn't this going? Here we are. There's the Smith. We've got John Smith, Samantha Smith, his wife, and little Johnny, 5 years old, and little Allison, 2 years old. Happy American family. You know, they've got a house, they've got some bank accounts, joint bank accounts, a car. Samantha will say that she's also inherited a separately titled money market account that she has in her name, but for the most part, they've got some joint assets, 2 little kids, and let's see what's going to happen to them. And like I said, we're going to have to put them through some tragedy here. So tragedy day number 1 is also babysitter fun time. Dad's got to go off to work. He's getting on a plane because he's going off traveling somewhere, wherever he's going. And Samantha, she's going to work too. That's why we give her this little briefcase. In comes the babysitter. The kids are happy. They love her. They know her. It's a typical normal day, right? Let's see. Well, you already know what's going to happen. Here's Samantha. She's on her way. She gets a call. Yay, she's happy. She doesn't have to go to work. Her meeting's canceled. So like a lot of moms, she thinks, okay, let me use this time to my advantage. I'm going to go to the gym. She puts her purse in her locker. She's on the treadmill. She gets a headache. It's an aneurysm. She falls. She drops dead. What happens? Here we have the frantic babysitter who's home. She's calling her. She can't get a hold of her, of course, because her purse is in the locker, right? It's locked up. She wouldn't have had that with her, so she's unable to reach her. So what happens next? Remember, we've got Dad who's off on a business trip to himself in another state. So in the event there was no planning in place and she died, you see what happens. We've got a police officer, a social worker. She comes in, she takes the kids. She took the kids from the babysitter. They're not happy. The babysitter has to leave because the babysitter doesn't have any authority. That was grandma and grandpa, maybe some friends that were there that came in and said, well, how about us? We can take the kids. And they said, no. They don't have authority. They had no legal authority. So there's no choice on behalf of the social worker and the police officer, but yet to take the kids into their care and custody until, as you can see here, John, who's on a plane, can get home to care for them. That's what happens when you don't have any planning in place, when there's no legal documents in place that give anyone authority to really care for the kids in that most crucial time. They can end up in the hands of social workers and foster care. Result number 2, if there has simple estate planning in place. Now she's sad, the babysitter's sad, they're taking the kids, right? Here comes the 2 people. Well, we can take them. We're grandma, grandpa. No, I'm sorry, you can't. We still need to wait for Dad to come home. Well, why is that? Let's just say she had a simple plan in place and she had a will, and that's what a lot of people do, and they name guardians in a will. But here's the problem with that. It still is the same result, because a guardian named in a will does not have any legal authority to act until 1, the will is found. 2, the will has to go through a court process called probate. And we're going to talk about that later. But the will and the guardians named in that will have no authority until that can be done. So I know a lot of you who may be listening to this might be thinking that, well, that's what you did. You have a will and that's all you were told. And I have no doubt that that's what you were told, because there are many attorneys, in fact, almost all attorneys, who completely overlook this whole concept of naming an emergency guardian. And a lot of attorneys think that it's just simply sufficient to name a guardian in a will. But you can see here that in that most crucial moment, there's really no difference for your kids. They still end up in foster care and in the hands of strangers instead of in the hands of the people that you love, if all you've done is name guardians in a will. What about her property? Well, let's see. What happens to her property? Well, all of her jointly titled assets, for the most part, are likely going to go to her husband, John. I say for the most part because it really depends on how title is held. And although they may be jointly titled, there are some little nuances in there to consider. If she didn't have a will at all and she just died, we call that intestate, then her husband would get $50,000 and he'd have to split the balance of the estate with his children. So no, it is not accurate to think, well, doesn't everything just go to the spouse? No, he'd have to split it with his children. And one thing to consider when you hear me say that is, it might sound like it's okay, but I can share with you a story where a widow thought the same thing, that she would have just inherited the house. It was jointly titled. Her husband died. She thought she'd get it. Well, that's not what happened. She ended up getting the house together with her children. She wanted to sell the house because she couldn't afford to keep it on her own, but her children did not want to. There was a disagreement there. So she was kind of stuck, and that created a lot of conflict. It wasn't an easy situation for anybody. And so that's something to think about when I tell you that you split that balance with your kids. That means there's a real possibility that not everyone's going to agree on what you want. The other problem here is, even if she had a will or didn't have a will, there's a huge risk of losing assets to the New York State Department of Unclaimed Funds, which today is $17.5 billion. And the reason why I have here in parentheses, it says investment account, is because remember when I laid it out, I said most of their assets are titled jointly, but she did have one account that was separately titled. Well, that one account that was separately titled, if John didn't know about it or wasn't named on it in any way and couldn't access it in any way, that's what's going to happen. Your assets are going to end up in the Department of Unclaimed Funds. I mentioned my dad and me and as the named executor and told you that I had no idea what he owns, where it is, how to access it. I mean, think about it. How often do you really have that level of conversation with people, that level of detail? I can tell you for myself, I don't. And I don't think many of us do. But that's the result, and that's the risk when you don't, and when you don't set it up. Those funds are lost. My mentor, her father died when she was in law school, actually. And it was a very similar situation to what my dad's plan very well could have unfolded to be, where he went and he paid $5,000 to an attorney and had all the documents made up. And there was one account, they couldn't access it. And to this day, I believe, and this happened a long time ago, it still sits in the Department of Unclaimed Funds. So this is a real serious risk, and it happens all the time. And most importantly, you see here at the end, I say that John or someone would end up in court, because whether she had a will or she didn't have a will, somebody's going to have to go to court and start a probate court process in order to distribute the assets. And we will talk about that later. So it's a mistake to believe, that's where I have the big no, it's a mistake to believe that all of her assets would have just automatically passed to John. If she had a will, it's basically the same result, but the big key difference is she would have at least had some control to say where she would have wanted her assets to go. And there'd still be a risk of asset loss doing that if she had nothing set up separately, and John would still have to go to court, but she would have a little more control over things, because if she had a will, she could say what she wanted. She could leave her instructions. And who knows, maybe John would have gotten more, maybe John would have gotten less. We don't know. So what's a takeaway already? Hopefully what you're seeing here is that an emergency guardian for your children, this concept is so very important. I can't stress it enough. And an emergency guardian does not need to be the same person as a long-term guardian, meaning the person that you trust to raise your children for their life when you're gone. But the emergency guardian, remember, is the one who can step in that most crucial moment when that bad news comes, to be there to comfort your children, sit with your children until the other parent can come or until another guardian can come. But they're the ones that can be there instead of foster care, instead of police. And it's so, so very important. And we name emergency guardians as just in every plan that we do, we name emergency guardians, because that's how important it is. And what I'm also hoping that you're taking away from this is that guardianship is as much about what happens in the event of you dying as it is about what happens in that most crucial moment, in that emergency situation. So it's about who's going to raise your kids, but who's also going to be there to care for them and comfort them and maybe be the ones to break the bad news instead of a police officer or social worker showing up at the school. Let's look at what happened if she had an advanced plan. Here's the babysitter. She's on the phone. She's trying to call dad. Now, if she planned with us, she would have already had, I'll let it play out first, but you see the guardian and everybody's happy. So what happens here? That went a little fast. But what happens here, if she had a more comprehensive plan, the babysitter would have called dad. Dad would have said, or she would have already known this because she would have had the instructions with her. Most ideally, that would have been the case, that the babysitter would have had the instructions, would have known who the guardian is. She would have called that temporary emergency guardian. That temporary emergency guardian would have already had the legal documentation that he or she would have needed. In this case, it was a male. He comes, he gets to sit with the kids and care for the kids and comfort them to take away some of that pain and the trauma while they wait for dad to come home. And so we see here that they got to be with the guardian as well as now they're with dad. There's no police, there's no foster care. And again, this is part of what we do in every plan. And we give everybody wallet cards so that if something does happen to them, inside their wallet, it says, if something happens to me, I have minor children at home, please contact 123. And it lists the names. And those people will have the instructions, they will have the documents, they'll have everything needed so that they can step in and act, including medical power of attorney to help with the children. And that's something that we take care of with every plan. We don't just name them, you see, we name guardians in separate standalone documents, as well as making sure that those guardians know their names and that the guardians have everything that they're going to need in order to act when and if that time comes. Now let's put him through another tragedy. John is going to pass away. He did learn a thing or two about Samantha's death, and he did go out and he did create himself a will, but nonetheless, he passes away and he's in a car accident. So let's see now what happens. We already know that he's a single parent at this point, raising his kids. He's created a will. But we don't know what else, right? Maybe he created some simple form documents. So yes, we know he's created a will. Odds are he's named his long-term guardians. I always recommend that you consider the things that you see listed here on your screen when thinking about who you should name. What are the person's values, spiritual beliefs, financial approach? And we really get into this in depth when we work with you to help you to decide who would be appropriate to name. But he's probably named guardians. They're in the will. So the kids aren't going to get to go there maybe right away because, like I said, it's a process that they have to go through first. That was just my alarm, so I can keep better time. Let's go on. So if you know who you'd name, go ahead, write that down, put that in the chat for me. I think it's very important to start thinking about that if you haven't already. So let's see what would happen. The children move in with the guardians, right? Here they are, they're with the guardians. We don't know what's going to happen with their money. We don't know how he left them the assets. Odds are he probably just left it to them outright, and you can see their kids. And you can't just leave money to kids outright because children cannot inherit. You have to be at least 18 years old in order to inherit any assets. So what would happen? Kids would have inherited it immediately upon turning 18. Now all of a sudden you see John's 20 years old. He looks broke, but he looks like he spent all of his money, right? This is the case when we get like teenage millionaires. They say that loosely. I don't know how many on this call are listening after are millionaires, but the point being that if you die and you've left everything to your kids in a will or otherwise, they can't get it until they're 18. And then at 18, they get it all, whatever there is. And when I say whatever there is, because in that gap period, from the time when they're little, when you pass away until they're 18, somebody's got to be appointed to manage that money. And that might be the person that you want to manage that money, but it's also very likely that it's not going to be the person that you want, because at the end of the day, the judge gets to decide. The judge would decide, and the judge would decide that as part of the probate process. Now, let's remember I said John passed, and now he had a will. So what does that mean? It means probate. Probate is a court-supervised process for distributing assets after a person dies, because the person owns their assets in their name. They can't sign title over. They can't do anything. It's got to go through this court process. And probate does not exist for your benefit. Probate exists for the benefit of your creditors, because you see, when you set out a will, and by the way, when you have a will, you have to go through probate. That's a big misunderstanding, I find. People think, I have a will, I don't have to go through probate. I don't have to go through court. That's not true. A will is only valid through that probate process, through a judge looking at it and giving executors authority, and through a judge basically, for lack of a better word right now, rubber stamping it. Okay, that's how it gets its effect, is through the court process. What a will does is that a will tells the judge how to distribute your assets. It's basically the instructions for the court, but it does not control all of your assets, and it certainly doesn't protect you from probate. It forces you into probate. So having a will means having to go to probate. It also means that all your private matters become public, because the probate process is a public process. Again, it does not exist for you. It exists for the benefit of your creditors. So one of the very first things that happens is public notice. Public notice. It has to be published that you have passed away and what you have, to give others an opportunity to come forward and say, this person owes me money. I want my money. Right? So that has to happen. And as you can imagine, that's also an invitation for conflict. It's an invitation for conflict among family members, for them to come forward and dispute what's in the will or what your wishes were. So it becomes a very involved process, and the court is involved every step of the way. And if you've ever been through court, the one thing I can tell you, no matter what it's for, even if it's traffic, you don't have full control. I know you might be thinking, well, of course I don't, I'm dead anyways. Yeah, but you can still exercise that control from the grave if you put the right plan in place before you die. And that's what's important. And through that court process, anything and everything can happen. I just want you to really think about that, because I've seen judges make one decision in the morning and literally make the opposite decision in the afternoon with virtually the same set of facts. So it's a big gamble anytime you're in court, no matter what the issue is. So going back to it, there'd be no distribution of those assets to the kids until the kids turn 18. And there's no distribution of the assets until you reach a certain point through that process. And when is that? Well, even in an uncontested probate matter, in other words, there's no issues at all, that could take up to 2 years now in the post-COVID world. Before, it was easily like 18 months. So it was still quite a long time, regardless. So it's a public process where everybody's put on notice, and there are predators out there, by the way. It can take a long time, even if it's not contested, like 2 years. And it's an expensive process. 3 to 5% of your estate, which is generally a pretty sizable amount, is going to go out the door right away. It's not even going to go to your loved ones. It's going to go to court fees. It's going to go to appraisal fees. It's going to go to bond fees. So it's a very expensive process. And the court's going to get to decide who's going to manage the kids' money for them until they turn 18. And if it's not the person that you've selected, then it can be somebody else. Again, it's up to the judge, and that person's going to charge by the hour. And I have seen it many times where even if there's just a small little bit of money, by the time that child turns 18, there's nothing left because it's been exhausted. Okay, so it's very important to really think about this, because when I say you lose control, you do, you lose that control. And your kids turn 18 and maybe there's nothing left for them because whoever was appointed by the court used it all, or maybe there's a lot left for them and they become like these teenage millionaires who really don't even know what to do with it. I don't know many young kids that can handle money. So I'm not going to discuss this again. We just kind of went through it. I just sort of said it before the slide, but as you know, minor children, they can't inherit money. Everything goes to probate. A judge is going to appoint somebody. Who's the judge going to appoint? That's really anybody's guess. We just don't know. We can hope that it would be the person that you would have liked and named, but we really don't know. When are they going to get it? Outright at 18 years old with no protections, no guidance on how to spend it. That's what happens. And you can do something better. Let's look at what that would be if they had done more of a comprehensive plan. Kids would receive their inheritance in trust, first and foremost. Here you go, it's in trust. There's instructions that mom and dad set out that said, we'd really love it, trustee, if you could give them money for their college education, if you can give them money maybe for a wedding or starting a business, things like that, so that it's protected, but it's trusted and it's given to the kids in a way that keeps it protected from their creditors, their accidents, their bankruptcies, or at least give the money to the kids at times or ages and stages that you would prefer, that you would select. So something, for example, I want them to get some of it maybe at age 25, 30, and 35, not everything at 18. So you have options when you give it to your kids in the form of a trust, which is almost always better than outright, in my opinion. So what is it? What's a living trust? Let's talk about that quickly. It's a will substitute, but it's kind of like a will add-on. All of my plans, I do both because I like to make sure that we are leaving no stone unturned. But what a trust does most importantly is it allows you to avoid probate. There's no probate, meaning no court, meaning less conflict, meaning privacy. Those are the highlights of having a trust. Think about it like a little red wagon, as you see here. If you put all your assets in your red wagon, then they're protected, right? Remember, if you're a kid, somebody comes, they want to take your toys out, they might be screaming, you might be upset, but not if they're in the red wagon and they're protected. So your share of any jointly loaned assets, they'd go into your trust, into the little red wagon. You would name your beneficiary designations on your assets to your trust, so they go into your little red wagon. They're protected as you move through life. All your trust assets that are in your little red wagon, they now become available to your loved ones immediately after you pass. They don't have to wait 18 months, 9 months, 2 years, whatever it's going to be. They become immediately available. It becomes a private process. Your loved ones only need to come into my office and see me. We just signed some documents over. It's not public, so there's no risk of predators or other people seeing what you owned and what you did with it. Okay, and it's a much smoother process for families overall. They can go as fast as they want, they can go as slow as they want, enjoying that privacy. And most importantly, you maintain full control and discretion and give your instructions of how you want your assets distributed and to who and to when and to what matter. In the event of incapacity, a trust protects you as well. Yes, there are separate documents like a power of attorney, a healthcare power of attorney, advanced healthcare directives, and living wills. These are all the documents, right? The buzzwords, and a will. And I can tell you that when you work with me, I do all of these documents, including a will, even if you design a trust. But what I want you to understand and take away from this is that a trust, that little red wagon and putting your assets in the trust, doesn't just protect you in the event that you die, it also protects you in the event of incapacity. If something should happen to you and you find yourself in a hospital, unable to make your own decisions, your successor trustee would be able to step in and make those decisions for you. So that's a real benefit. And think of, Britney Spears and the whole guardianship, conservatorship thing. Let me tell you, that's not an exaggeration. It happens to normal people, regular people, not just celebrities. I had a woman come talk to me once that was under the guardianship of her estranged husband. It sort of sounded like he was an ex-husband by that time. That's how bad the relationship was. She seemed perfectly stable to me, not any mental conditions. Of course, I'm not an expert, but no matter what she did, she couldn't get out from underneath that guardianship. So once those get in place, they're super hard to unwind. And that's what's important to also know about a trust. It protects you in the event of your death, but also in the event of your incapacity. You get to decide who you trust and who you want to manage your affairs and to what extent. So lesson 1, right? Our children are our most important assets. I know I don't have to teach you that. You already know that. They need to be protected no matter what. But hopefully what you've learned here today is that guardianship is just as much about who's going to raise your children in the long term as it is about what happens in the short term. And as part of our plans, we cover all those bases. We help you also to create very specific instructions for your guardians so that they know how you want your children raised. And we put in place medical power of attorney so that they can handle all of their medical needs when you're not available. So it's very comprehensive. And again, we also include those wallet cards as part of every, what I call the kids protection plan. Wills, lesson number 2, wills Do not avoid probate. Please understand, wills do not avoid probate. Wills force you and your family into probate. And probate is a long, public, and costly process. They do name permanent guardians in a will, yes, and that's very important. I always say it's a great first step. It's just not enough in the end. Lesson 3, a review of all of your assets must be and should be a part of every estate planning conversation you have with any attorney, financial advisor, anyone you're talking about. It must, in my opinion, involve a review of all of your assets. It should never involve just a quick little questionnaire of what do you want? Okay, fine, no problem, bing, bam, boom, here's your docs. Because that's when assets get lost. That's when mistakes happen. That's when this plan that you pay for and you feel proud about, like my dad, that's when those plans fail and you've paid for nothing more than expensive paper. Because if you do not have a full comprehensive conversation about all your assets and have an attorney or the person you're working with checking that and making sure of the beneficiary designations, then you're really just still just as exposed to all that risk. And asset lost, as I said, right now, $17.5 billion. And I can tell you less than a year ago, I'm pretty sure it was like somewhere around 15 billion. So that is how fast this fund grows. I don't know what happens to the money after. People ask me that, I have no idea. But all I know is that your hard-earned money, your hard-earned assets won't go to the people you want necessarily. They go to New York. So all of this, if all you have is a will, of course, it invites conflict. The other thing that invites conflict is if you just went to a document type planning attorney and they didn't have that full conversation with you and they give you a trust, much like my dad, and they don't do anything after that. They don't take the time to put all of your assets, all your goodies inside the trust, inside that red wagon. They don't do that. Again, you've got expensive paper. And when I say by doing that, it doesn't mean necessarily that they are actually doing that. In fact, in my office, we have options. I can do it for you, or I give you all the resources so you can do it yourself. But the point is, it's got to be done. And at a minimum, somebody's got to be checking to make sure that it's getting done. So what do? We fund your trust. We check all the designations. And if we don't fund it for you, we give you everything that you need so that you can do the funding yourself. We stay in communication with you. We stay in relationship with you because, again, I see myself as acting as your personal advisor, not just for now, but for later down the line and your family when they need me. So it's important. And what that means is as you continue to go through life, you've got new goodies putting in your wagon. Maybe you got some coming out of your wagon. We keep all that up to date for you. Again, we want to eliminate the possibility of conflict. We want to make it simple and as easy and straightforward for your family when and if this terrible time comes for you. So how are we different? Well, traditional document attorneys, as you know, as I've mentioned here, it's an hourly fee. We don't charge hourly fees. We don't just do knee-jerk responses to the problems. We don't just do transactional documents, one size fits all kind of planning. That's not what we're about here at all. What are we about here? We are about flat fee, transparent pricing. You will know exactly what your plan is going to cost. You will choose that fee, and you will choose that fee based upon what is important to you. Everybody's different. Everyone is different family dynamics, different goals, different objectives. And I take all of that into consideration as well as your assets. And I help you decide what's going to be worth it to you at a cost that you can afford. And then we move forward. We help you do that planning ahead, basically. These plans are created specifically for you. Are they long? Are my documents long? Oh yeah, they're super long. Why? Because they're very comprehensive. And I build in so much flexibility. But again, it's not this one size fits all kind of a thing. And I'm there for you, like I said, as your trusted advisor today, tomorrow, and later, because the last thing I want is for your loved ones to be grieving and then scrambling on top of that about how are they going to manage your estate and who do they turn to. So you'll know who that person is. They'll know who that person is. And hopefully we would have had an opportunity to even meet them before that time. That's my promise. My promise is that your estate plan leaves no stone unturned, that we will give you peace of mind, knowing that your loved ones and your assets will be kept out of court and will be kept out of conflict. That's our promise. That's our goal. How do we do it? Well, we start with that initial family wealth planning session. It's a 2-hour working meeting. And in that meeting, we will go through your family dynamics. Who will survive you if something were to happen to you today, if you were to die today, or if you were to become incapacitated today, who would survive you? What does the dynamic look like? And we look at all of your assets. And from there, I lay out for you on a whiteboard exactly what your reality looks like. And you'll be able to tell me what's okay with that and what's not okay with that. And if there's something that's not okay and something you want to tweak, some gap you want to fill, then we move to the next phase. And I discuss with you the different plans we have, and you get to pick one. You pick one based upon you and what's important to you and what you're trying to achieve. And most of the time we get all that done in that first initial planning session. Sometimes we have a follow-up meeting, a design meeting, where maybe we're just rounding out some of the details on things. But in the end, we get to a point where we know exactly what it's going to look like. I bring you back about 4 weeks later or so. We do a signing ceremony, and this can also all be done virtually. And I even have systems in place where we can come to your home. But we do a signing ceremony, and then after that, we have one more meeting, and that's called our final meeting. And in that final meeting, I actually give you your documents, and it's a binder delivery meeting. What we also do at that meeting, though, which I think is super cool, and every family that I've worked with really loves it, is a legacy interview or a legacy conversation. And what that looks like is me putting you on camera and asking you things like about your life. What's most important to you? What's a story you want to share? Tell me about how you met your spouse. What's a lesson you want your kids to know? That kind of thing. And the reason why, again, is because I know and I get it. Yeah, estate planning is for you, but it's about the people you leave behind. It's about the people you love. And quite honestly, the people you love and leave behind, I'm sure you'd agree if you've lost someone, the assets is one thing. Yeah, but what's most important? What do we typically miss the most? It's it's what made that person that person. It's their heart, it's their love, it's their voice, it's their stories, it's their values. And that's what we try to capture in that legacy interview. And we do that when we give you your binder. I've got systems in place where we can do that every year, and you get a legacy system library, which is super cool too, I think. But the main thing to know today is it's minimally a 3-meeting process. And we'll count maybe 3.5 if we got to round out some details in the design meeting. It can take about 10 weeks, start to finish. The only heavy lifting on your part really is doing the pre-meeting homework. And that pre-meeting homework is just an opportunity for you to get really organized financially, because all you're doing is you're documenting all your bank accounts, the value of your home, the value of your car, and you're putting that into one place for me. And quite honestly, even if you decide after that family wealth planning session that the way things look right now and your current reality is perfect, you don't need to make any further adjustments. We don't need to put any different planning in place. That homework that you do to prepare for that meeting is invaluable regardless, because you can keep that with your documents. And now at least your family's got something to go on. They know where your assets are. They know how to access it. It's not going to end up in the State Department of Unclaimed Funds. A little bit about our plans. We've got different levels of planning. Like I said, it's very transparent. Our base plan starts at $3,500. This is our will-based plan. Of course, it includes all those popular documents, the will, the healthcare directives, powers of attorney, the legacy interview, and a full and comprehensive kids protection plan. And I keep talking about minor children, but it's also important to know that if you've got a child who's 18 years old, 19 years old, 20 years old, going to college, there's some planning that they need in place too. And we include that. So if you've got kids kind of in that age range, maybe not minors, we just swap it out and we take care of them too for you. The other thing is that when you plan with us, we review your plan every 3 years for free. So, and why do we do that? Because we want to make sure, your life's going to change, number one, the law is going to change, number two, and your assets are going to change. So we build that in for free. Every 3 years, we're getting back together. We're reviewing this with you to make sure that this plan is going to work when you need it to work. Base family plan starts at $3,500. Our trust-based plan starts at $5,500. And it includes everything I just said in that family plan. Okay. But in addition, you also get that little red wagon, that joint revocable trust with it. Everything else is included. We also do this beautiful asset inventory. So again, your family knows what you have, knows where it is. We are trying to make this as airtight as possible, as simple as possible for your family. And that's the trust plan starting at $5,500. Yes, there's a range here. And the range is because I'm going to ask you questions through the process. And again, like I said, it depends on you, and it depends on what is important to you. And if certain things are important to you, you might opt to spend the extra money. If not, you may not. And there is no one size fits all, no one right answer. Our kids protection plan, we can do this as a standalone product as well. That's only $750. And as I mentioned, you've got kids maybe between 18 and 21. I still call them kids, but young adults, I guess, going off, entering college. There's still documents that absolutely need to be in place if you want to protect them and yourself and your sanity. Because if they're not, let me tell you, your child can prevent you from accessing any school records, meaning they could decide to quit school. You wouldn't even know. You're still paying the bill, maybe. They could leave the dorm. You wouldn't even know. So we put stuff like that in place. We put in place something so that you can still access their medical records. So also, if something should happen to them, you can make medical decisions for them. All of this is important. And when your child turns 18, if you don't have these documents in place, you're out. You're out of the loop. Your child can do whatever they want. And these things are very important to, again, protect them. And I would say in that side of the coin, it's really probably more about protecting you and your own sanity and peace of mind, and knowing that your child, who's now 18, still has his or her bases covered. So I told you in the beginning, if you stuck with me, I give you an opportunity to meet with me for free and also some additional savings. And I thank you so much for doing that. And here we are. That's my offer. I call it the golden ticket. I call it the golden ticket because it's $1,000 of savings to you. You get $250 credit toward any future plan if you watched this video and you stayed till the end. I appreciate you for doing that. Mention the golden ticket when you book so I know, and I can give you the proper credit. You do need to book your family wealth planning session within 24 hours of watching the video. So that is key, because I am trying to incentivize you to act. Why? Because I know about that monster of procrastination. I'm guilty of being under his wraps as well, I guess, if you will. So I want to give you an incentive, and that incentive is $250. And also, quite frankly, it's easier for me. I'm not tracking you down, so you're making it easier for me. And I'm giving you $750. That's the value of the family wealth planning session. If you book that family wealth planning session and you do your homework and give it to me 3 days in advance. So that's really all you got to do. And there's no obligation. Like I said, what we do in that family wealth planning session is we just have a conversation, and I'm going to lay out for you what your current reality looks like. And you might be okay with that, and that's fine. And then you get to walk away with full, complete knowledge, understanding, and a real peace of mind, knowing that what you've got in place right now is going to take care of your family and going to take care of your assets exactly as you would want. But if, when we go through your current reality, there's some things you don't like, maybe some risks, maybe some gaps, things like that, we need to kind of just shore up a little bit, then we'll put a plan in place. And that plan we're going to talk about, you're going to pick what makes the most sense to you, and we're going to move forward in a way that's going to work for you and work for your family. So there you have it. Again, thank you so much for being here. Remember, it's not true to think that you only need to plan if you have money. You don't need to have a lot of money. You don't need to be rich. You don't need to be old. And I hope that you can see why. I hope that came through here in this presentation strongly, loud and clear, that planning really truly is for everyone. Everyone, Mr. and Mrs. Smith, average Joe, planning is for you if you have someone or something that you want to protect. And please don't make the mistake of thinking, well, if I pass away, my spouse will get everything. We know now that's just simply not true. And if you think, well, you don't have enough money for this, again, the state will have a plan for you. It may not be what you like, but I can guarantee you that the money that you will spend now on planning will be far worth it to you and far worth it to your family, and be far less expensive to your family in the end. Because if it's not, then it isn't worth doing. So that's how I look at it and evaluate it with you. I appreciate you again for being here. I thank you so much. I don't see that any questions came through, so that's great. Please, if you would like to take advantage of that offer, get online. You can use this QR code here or go to this link, dpremaestateplanning.com, and schedule your family wealth planning session in the next 24 hours for your golden ticket. Thank you so much. Enjoy the rest of your day, night, or wherever you may be listening to this.